That is strict scrutiny.
Can I question the premise that you are putting forward? Even if I agree with you that equal protection is about, is this classification justified? I think that begs the question, what is the classification? And so to the extent that you have an individual who says what is happening in this law is that it is treating someone who is transgender but who does not have, because of the medical interventions and the things that have been done, who does not have the same threat to physical competition and safety and all of the reasons that the state puts forward, that's actually a different class, says this individual. So you're not treating the class the same, and you're not, how do you respond to that? In other words, the as-applied challenge essentially redefines the class, or one could think of it as that. And so what's wrong with that, number one, and how do you square that with our holdings in Caban, which Lair later described in this way? In other words, Lair suggested that Caban was establishing that as-applied challenges of this nature do exist.
Certainly, take the second question first.
Yes.
Caban says nothing about as-applied. I know that Lair says later this was an as-applied case, but simply reading Caban, it does not say that. It simply applies intermediate.
No, I understand, but those two cases were in juxtaposition with one another,
Yes.
and Lair comes out the way it does, distinguishing Caban on the basis that it's an as-applied challenge, and we in Lair have a facial challenge, and it's basically the same facts. So if you're right, those two cases can't come out the way they do.
I don't think so, Your Honor. Again, Lair was actually briefed as a standing argument of maybe you might be able to argue that this law is overbroad, but you individually are not in the overbroad part, and therefore you don't get to challenge it. The court didn't use standing language, like express standing language in the opinion, but that is the logic of the opinion.
Mr. Hurst.
Yes.